guys. Hey Bree, what's going on? Hey Steph. Hey. Well, Steph, I was waiting for some more folks to come on in, but I'm gonna go ahead on and let you guys know what's going on right now with Mr. Kelly. The money bandits have struck again. The money bandits have struck again. This time it's for millions of dollars. For millions of dollars. Did y'all get my notification that I'm live? Because I'm not seeing anything. I'm so glad I caught you live. I've been so busy. I just posted that today. I said, Lord, they trying to drain that man. It's more. Which one are you talking about, Gilda? Which one are you talking about? Which one are you talking about? No notification? Okay. Which one are you talking about? Not the one that they posted with the 500,000. It's more now. No notification. Okay. No, it just happened. No, it's more. Gilda, they just did another one today. There was one yesterday, and then they did one today, this afternoon. It's another one. This one is millions of dollars. Millions. Yeah, that was the other day, Gilda. That was the other day. All right, y'all. I'm gonna go ahead on and just let you guys know. There's been a ruling by the judge today, and this ruling has to do with Mr. Kelly's lawsuit with Lisa Van Allen, Lizette Martinez, Kelly Rogers, Faith Rogers, Roger Gartrell, and Jim Pratt. You got these names? Those are the people that sued him. This lawsuit started back in, if I'm not mistaken, right after he lost. Right after he lost the case. Remember, they set out to file a lawsuit. Well, they got a judgment, a ruling from the judge, and the amount that is going to be taken from him is a lot of money. You have Lizette. D Nice, this is not for this one. This is for the New York case. Remember, he had two civil cases against him. One was just what's the name by herself? What's that girl? What's that girl name? Faith Rogers. One was by herself. Then the other one was Faith Rogers, her mama, that fake brother of his wife, his ex-wife, and the mother. Yeah, it was right after. Yeah, thank you, Kia. Right there after he was found guilty in Chicago, they put a he needs to win his appeal, win his oral argument for New York. We still don't know. We don't know anything about the oral argument. We don't know what date that is. You have to wait till the court give us the date. I'm checking constantly for it. But let me just tell you some of the amounts that has to be paid out. Okay. Hold on a second. My daughter's calling me. Hold on. Okay, sorry about that. The amount, okay, let's see. Okay, the amount, I'm going to give you the amount, and then you guys will know. We have Lizette. Lizette amount is $1,150,000. That's Lizette, right? No, that's hold on. Let's see. Yeah, that's Lizette. And that is for compensation damages. And then he has to pay $700,000 for punitive damages. That's for Lizette. Then Don Russell has to pay $100,000 for Lizette. Lisa Van Allen, Robert has to pay, let's see, $206,250,000. That is for compensatory damages, and $700,000 for punitive damage, and Don Russell has to pay $100,000. Kelly Rogers, Robert has to pay her $700,000. That's punitive damages. And Don Russell has to pay her $100,000. Faith Rogers, Robert has to pay $1,500,000, and that is compensatory damages. Punitive damages is $1,050,000. That's how much. Well, there is because remember he supposedly made those threats to her. Remember the threats, the bomb threats, and threatened to put her pictures out and all that kind of stuff. That's why he owes. And then Don Russell owes uh Faith 200,000. That's how much Don Russell owes Faith. That's how much they have awarded them to give. And that guy, Roderick Gortrell, it says here that Robert has to give him 700,000 in punitive damage and 350,000 on compensatory damages. That's for Roderick Gertel. And let's see, Pratt. I forgot to get Pratt. Hold on, Pratt has to. Robert has to give Pratt 350,000 and 700,000 punitive damage, and Don Russell has to give him 100,000. So that's what the judge has ruled on that. Yeah, that's what the judge just ruled. Yep. Another civil case lost. So it says here, he has two civil cases. He has the restitution. He has two restitution cases. There's two civil cases. The two civil cases in New York. Yep, that is what he has to give. This was just ordered today. Spit and Fire. This was done today. They said that he did these intimidations, and these people, some of them suffer from stress disorder, anxiety, hyperventilation, panic attack. They do avoidance, isolations. A lot of things have been done because of supposedly Mr. Kelly. So they have been awarded these. So they have been ordered and they've awarded. So they gave the address where they need to send the funds to. And it's a judgment. Who represented him on the civil case? You want me to do some homework? Are you asking me to do some homework, Miss Spitfire? Are you asking me to do more work than what I do here? Are you asking me to do that? I just came to give y'all some information. That's what I came to do. I just shared the information. I went and got the information. I shared it. Now I'm about to end my live. So, and that's it. I'm not knowing this stuff, but I appreciate Spitfire. It's not directed to you, honey. Trust me. You know you're my girl. It's not directed to you. Since folks think I just sit on the internet and don't do any work. So I'm gonna take my butt on. I just want to bring y'all some information of what's happening to Mr. Kelly, and I'm about to skedaddle. Y'all asking me questions. I don't know. I am not the attorney. I am not in the court system. I don't know. I'm just bringing y'all information. I'm not concerned about his money. I just want him free. His money issues is all his problem. Make them pay for it. That's it. Folks run up in here like roaches to get information from Sylvia. I am not an attorney. Nope. And Red Bunny, you say my child look like that girl again, I'm going to punch you in the eye. My child do not look like, not all Black people look alike, ma'am. That girl, my child, do not look like that girl. You want, because you know she'll have a fit. You keep saying that. Oh, I thought that was Adrielle. You stop. You once said it. You once said, "Oh, I thought that was Azriel." No, that is not her. It's my child. My child do not look like her. My child look like me. You know, Dallas do not like that. You get tired of y'all saying that. She do not like that at all. Okay. Um. 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 Gazelle, don't be doing that crying face. No, you keep saying y'all keep doing that. Is this the end of civil case? Is it the end for civil case with Bill Cosby? No, I don't think it'll ever be the end for Rob, because they're gonna keep trying and keep trying and keep trying. They're gonna keep trying and keep trying, keep trying. Yeah, my daughter will not have bags under her eyes. Can he appeal? I think all of it can be appealed. Spitting fire. Nothing is final. You know, with cases, you can always appeal and ask another higher court to look at it. Yeah. I think everything until it says final and no more, that's when you can't appeal anymore. But I believe you could still appeal, just like Bill Cosby. He's appealing his. Weinstein appealed his. But my hey, Ashley. Ashley. There's no gangster over here. I ain't no gangster. No gangster. Mm-mm. But he can't appeal it. I think she's asking, can he appeal the judgment the judge just did on for the money? That's a lot of money, y'all. If you calculate it, I'm going to repeat the amounts again. You ready? The first amount is with Lizette. Lizette, he has to pay $1,150,000 in compensation, right? Then he has to pay 700,000, right? That's with Lizette. Don Russell has to pay 100,000. I don't know where they're gonna get that from. Don Russell, I don't know about that. Right? Lisa Van Allen, he has to pay 1,200,000 1,206,002. No, wait. Let me read that again. $1,206,250. That's how much he has to pay Lisa Van Allen for compulsory. And then for punitive damage, he has to pay her 700,000. Right? And Don Russell has to pay Lisa Van Allen 100,000. Okay. Kelly Rogers, which is Faith Rogers' mother, he has to pay her $556,250. That is the compensatory. And the punitive damage for her is going to be 700,000. $100,000. Okay. And Don Russell gets to pay $100,000. Faith Rogers, he has to pay $1,500,000. That's for compensatory. And for punitive, he has to pay $1,050,000. That is for Faith Rogers, and Don Russell has to pay $200,000 to Faith Rogers. Now Jim Pratt, he has to pay $350,000 in compensatory damages, and punitive he has to pay $700,000. Don Russell has to pay $100,000. And to Roger Gertrell, he has to pay $350,000. And the punitive damage, he has to pay $700,000. And Don Russell has to pay $100,000. Did anybody calculate all that? Let me calculate it. Let's see if we could get water from a turnip. Grand jurist, that you want the other one read from yesterday? You want the other one read? Okay, grand jurist just gave me Cash App for the yesterdays. Hold on a second, let me play the music. That's from yesterday. Oh my God, look who is in here. Wow, travel the world. Hello. What the wind blew over here. Good afternoon, young lady. Okay, Queen says they had an inquest at T-Girl. So his lawyer was contacted and one of them responded and didn't follow through. I'm looking at it. Okay. All right. She wanted me to read the other day's thing. I'm gonna read the other day. Yeah, it's a lot of I don't know the strategy to this. This didn't sound like Jennifer's doing. I don't know what the strategy is behind all this and what's going on. All I know is that I don't even know, that's all his money. Who's Jada? Lita said Bonjean dropped the ball. I don't know. I don't know who dropped the ball. I know originally she was not on the case. It started back in Platinum case just happened recently. The other case happened in 2018. The Pratt one just happened because she knew about this case. That's what's the name said. I don't think she was. Yeah, she was on. This is the new one, Spitting Fire. This happened right after he lost to the Illinois. Remember, Van Allen came on. Kelly, and these are new lawsuit. These are not old. Those are new. Please not curse in the chat. Travel the world. I'm trying to keep this place clean. Please don't put cuss words in the chat. Thanks. All right, the one from 2008 is still active. Yeah, that's the one with Faith Rogers. That one is Faith Rogers. That one, I just talked to you guys about that one a couple of days ago, 2 days ago, I think. Was it yesterday or the day before? I talk about those where I let the system read it. No. Yeah, this is a more lawsuit. Yep, this is more. This is the one. Remember, right after he lost the case. Lands Fair, yeah, that's in Chicago. Yeah, all of them gonna sue. Every last one of them gonna sue. You know that, because a lot of them are not getting what they wanted, and the judge did tell her she can go ahead and file a lawsuit because she wasn't going to get it in restitution, because that's not the purpose of restitution. It's for money spent on certain things. I just try to keep you guys abreast of what's going on. And Grand Tourist, I was going to go ahead and read that. Is that the one, the too many pages? Let me see. Which one were you trying to give me? Now, I'm not reading. This is new stuff. I'm not reading that new stuff. This was you wanted me to read which one was it that where Steph, text me for a minute, please. Look on the phone. Text me for a minute. Infamous Sylvia, isn't Jennifer suing the DOJ? Yeah, that's what I heard she was doing. Yeah, that's what I heard she was doing. Well, I know one thing. They're trying to get water from a turnip. Okay, I'm supposed to be reading the brief. 8 days ago, Jennifer's. Oh, the brief. Okay, gotcha. All right, I'm about to go there. They're going after Michael Jackson again. Yeah, they are. They are. They're not going to stop until they dry these people. That's what they're going to keep doing. They're going to keep coming, and keep coming. All right, let me go get this brief so I can read for Missy, and then I can go take my butt on, take care of my household. Hold on a second. Okay. You said the brief? Oh, that brief is too many pages. Wait a minute. Hold on. I thought you were talking about the garnishment. I thought you were talking about the garnishment. The brief, you know how many pages the brief are? I thought you were talking about the garnishment. Oh Lord. The brief is too many freaking pages. Oh, Father God. Hold on. Lord have mercy. I got a husband to feed, y'all. I'm gonna have to do 2 parts on that one. Hold on a second. Let me go find the garnishment because I am a woman of my word. I did say. Let's see. Where is it? Hold on a second. Somebody's texting me. Queen, you are so welcome. You are so welcome. Folks folks say they do things better than me. Spit fire. You heard that, right? Shout out to one pop. Because I was watching her show. Somebody claimed they do stuff better than me. They do interviews better than me. They do all this stuff better than me. Oh Lord, he can do 2 parts or 3. The robot voice is too much. Ma'am. I told y'all I changed it to the robot voice because too many people was complaining about my reading. So I fixed that problem. I fixed that problem with the robot. So you should tell the people stop complaining. Because that's why I don't stay on here too long anymore either. I get off. I ain't got time for that. I ain't got time for that. Ready? All right, argument. Hold on. Hold on, somebody just send me something. Hold on, y'all. Hold on. No, this is New York brief. Illinois doesn't have to be. The government responds on the 1st of September, which is Friday. The government has to respond to the one in Illinois. The one in New York is the one that Jennifer responded to. You got it? Spitfire. This is the one that was done on the 16th of August. Rosie, you back here? You back home? Yay, Rosie's back home. You read that already? Grand Jurist. Spitfire read it. Did you go over there and listen to her? Spitfire read it. Okay, y'all ready? Let me see. Number 1. This is the argument. It says here, Spitfire read it. Spitfire, I didn't read it. I let the machine read it because I get tired of people. Well, thanks for the update. I appreciate it. I gotta go. You have a good one, okay, Spitfire. Number one, the government failed to prove defendant guilty of racketeering, where the record is devoid of evidence on an enterprise comprised of members who shared a common illegal or fraudulent purpose, and where the defendant and the alleged enterprise were in distinct. All right. The government largely concedes that it did not prove beyond a reasonable doubt that defendants' inner circle shared a common purpose to engage in a fraudulent or illegal course of conduct. Instead, the government makes frivolous argument and insisted that it was never required to prove a common purpose of illicit conduct or the first place, even though the indictment charged it. The government now seeks to constructively amend the indictment to remove an essential element of its enterprise theory to circumvent its proof problem. The government makes virtually no efforts to address defendants' separate contention that evidence of an enterprise was insufficient, where the defendant and the alleged enterprise were indistinct. The government's evidence at this best show only that the defendant used his status and authority to engage his employees in routine, sometimes odd tasks that unwittingly facilitate his private sexual activity. That the government suspects that some of the defendant's employee turned a blind eye or knew more than they let on is not sufficient evidence that the member of the so-called enterprise shared a common purpose of promoting defendant's illegal sexual conduct, a necessary element of the charged RICO offense. Hey, Nakia. A, the jury instruction was not deficient, were not deficients. The evidence was. Preliminary, the government did not argue below that defendant's Rule 29 challenged the government's evidence of an enterprise was misplaced and that his objection was actually to the court's jury instruction. More importantly, the district court concluded that the question of whether an enterprise was proven beyond a reasonable doubt was a proper Rule 29 claim. The government's attempt to recast the sufficiency of the evidence challenge as a defective jury instruction issue is successful. Having proposed the jury instruction, the government knows that they actually stated the law and that they included that government's theory of the illicit common purpose, and the most important, that they told the jury that the government was required to prove an enterprise as charged in the indictment. The problem is not with the instruction, it is with the proof. Critically, the government fails to acknowledge that the jury instruction incorporated language from the third superseding indictment, including the government's claim that the common purpose of the enterprise was to engage in an illegal common purpose. In the instruction setting forth the existence of an enterprise, the juror was expressly instructed that the indictment alleged that the purpose of the enterprise were to promote R. Kelly's music and the R. Kelly's brand, to recruit women and girls to engage in illegal sexual activity with Kelly, and to promote pornography, including child pornography. DE 303, page 24. The instruction also told the jury that although the government is not required to prove each and every allegation about the enterprise must be essentially the one alleged in the indictment, ID page 29. In other words, the government conceded that it was required to prove that the defendant's employee or so-called inner circle shared a common purpose to engage in illegal or illicit conduct, namely to recruit women and girls to engage in illegal sexual activity with Kelly and to produce pornography, including child pornography. The government pretends that it never charged an illegal common purpose, populously declaring the party's proposed instruction adopted by district court. It set a benchmark for the government to meet. The government met the mark, and Kelly now objects that the government did not instruct. Wait a minute, hold on. Is this hers? Hold on a second. Is this Jennifer's? Am I reading the wrong one, y'all? Oh, yeah, that was Jennifer. Sorry. I had to go back. I want to make sure I was reading the right one. Okay, let me get back. The government pretends that it never okay, I read that part. Kelly now objects that the government did not instruct sufficient evidence for the jury to find another previously unsuspected required was met. GOVBR 41. Defendant agrees that the jury instructions is set benchmark for the governments to meet. One of those benchmarks was to prove beyond a reasonable doubt that the common purpose of the enterprise was to promote defendants' illegal sexual activity. The government failed to meet that benchmark. Defendant did not introduce any unsuspected requirement. Rather, the illicit common purpose element was charged, set forth in the jury's instructions. The jury was instructed that the government was required to prove the enterprise as charged. The government simply failed to prove the charged enterprise theory by arguing that it was not required to prove a common purpose of illegality as the indicted charge. The government is attempting to constructively amend the indictment on appeal to remove the essential element of the RICO enterprise theory. A constructive amendment occurs when the evidence presented at trial altered the essential elements of the charge specified in the indictment. United States versus Dove. The indictment here alleged that a common purpose of the enterprise was to promote defendant illegal sexual conduct. The government now claims that it was never required to prove, she said to prove twice, to prove the illegal common purpose is nothing more than an unconstitutional constructive amendment to the indictment. The government alternately argues that even if Kelly's brief challenging the sufficiency of the evidence were interpreted to challenge the jury instruction. The error is not plain error. There is no error in the jury instruction, plain or otherwise. The jury was expressly told that the government was duty bound to prove its charge theory of an enterprise, which included a theory that common purpose of the enterprise was to promote illegal sexual conduct, not merely promote defendants' music. The government failed to prove its theory of an enterprise, and the conviction must now be reversed. The government can cite to no authority that allows it to amend the indictment on appeal to fundamentally alter its theory of the purpose of the enterprise. So she's basically saying that they trying to change some of the things during the appeal, which they did not meet before, so therefore it should be reversed on that part because it did not meet the requirement. B. An enterprise require a shared purpose of fraudulent or illegality of as the government charges in its indictment. The government contends that it was not required to prove a shared illegal or fraudulent course of conduct. Government BR at 42. This position by the government represents a profound change of heart where it charged defendant with an enterprise and that has a common purpose of illegal course of conduct, and then instructed the jury that it was required to prove that illegal common purpose. As argued above, the government was required to prove its theory of a common purpose as pled in the indictment and as set forth in the jury instruction. Recognizing that its proof of a common purpose as pled in the indictment was insufficient, the government repeatedly attempts to recast the defendant's argument as a challenge to the structure of the organization. Defendant's RICO charges has nothing to do with the structure of defendant's organization. It is well established that an enterprise can have either a legal or illegal structure, but an enterprise cannot exist without its members sharing a common purpose to engage in a particular course of fraudulent or illegal conduct, as the government knows, having pled such a purpose in the indictment. To hold otherwise would mean that any rogue bad actor operating in a legal organization could be prosecuted under RICO. This scenario stretches the RICO statute beyond and contrary to its purpose. The government attempted to distinguish defendant's authority by repeatedly succeeds in proving defendant's point. For example, the government argues that in First Capital Asset Management versus Satinwood Inc., the case numbers there, the alleged common purpose was one grounded in fraud to conceal assets from creditors and the bankruptcy court. And thus, this court necessarily analyzed whether such a common purpose has been adequately alleged. Government BR at 44. The government seems to forget that it too alleged that the common purpose of the enterprise in this case was to promote the defendant's and his illegal sexual conduct. Consistent with the government's own argument, this court should necessarily analyze whether such a common purpose has been adequately proved. The government's attempt to distinguish the First National Bank versus Gelt Funding Corp., case number there, Molt versus U.S. Life Title Insurance Company in New York, similarly failed. In both cases, the complaints allege a common purpose is illegality. Just as the government did in this case, having charged a common purpose is illegality amongst the so-called member of the association, in fact, enterprise. The government was required to prove that common purpose of illegality. Indeed, if the government had not charged a common purpose of illegal conduct in this case, the defendant's motion to dismiss the indictment would have prevailed. The government suggests that Satinwood, First Nationwide, and Mole are not good law because the cases preceded the Supreme Court's decision in Bohl versus United States, in which the Supreme Court held that an association, in fact, enterprise need only to have a purpose relationship among those associates with the enterprise and longevity sufficient to permit those associates to pursue the enterprise purpose. Gov. BR at 45. Bohl does not help the government's case. In Bohl, the defendant was charged with a number of bank theft that were allegedly conducted by a group of loosely organized individuals operating within a larger structure. As the court observed, the participants in these crimes included a core group, among others, who were recruited from time to time. Each theft was typical, carried out by a group of participants who met beforehand to plan the crime, gathered tools, and assigned a role to each participant would play, such as lookout and driver. The participant generally split the proceeds from the theft. The group was loosely and informally organized. It does not appear to have had a leader or hierarchy. ID 941. The Supreme Court held that this association in fact qualifies as an enterprise for a RICO purpose, notwithstanding the absence of a clear leader. The court was not present for the question, nor did it answer whether the member of the association in fact must share a common purpose to carry out the illegal course of conduct, or whether a single bad actor acting within an organization can be guilty of RICO. Indeed, in Boyle, the association in fact's entire purpose was to carry out bank robbery. A decidedly criminal purpose. If anything, Boyle drives home defendant's point that the evidence in this case did not show that the members of the defendant's musical collective, whether characterized as formal or informal structure, engage in the conduct demonstrating a shared purpose to carry out an illegal course of conduct. The government purposely distorted the defendant's challenge as to the structure of the enterprise rather than the purpose of it. If, within the context of a legitimate business as the defendant's business was, there does not exist a group of individuals with a shared purpose to engage in a course of fraudulent or illegal conduct. There is simply no RICO enterprise, even if the head of the legitimate business is independently engaged in illegal behavior. The government points this court to the language in United States versus Turkett and Andrerio versus Andrerio for the for the proposition that the association in fact enterprise need not have some sort of illicit, much less fraudulent common purpose. Gov. BR at 48. The government did not take this view when it presented its theory of a common purpose of the grand jury, or even when it offered its jury instruction. In any event, neither the Kirkett or D'Andro courts were presented with this precise question because there is no dispute that whether the common purpose of the alleged enterprise member were engaged in a criminal or fraudulent course of conduct. As explained in his opening brief, apparently overlooked by the government based on footnote 7 of its brief, in Kirkett, the court was tasked with deciding whether an enterprise could include an entire illegitimate enterprise. In its discussion, the court compared various associations, in fact, that were entirely criminal in nature and were a combination of illegal and legitimate activity. Turkett did not provide an example of an association, in fact, whether its members share only a legal purpose. Similarly, in D'Andrio, the association, in fact, enterprise had a legitimate structure as far as its stated purpose was to settle the estate. But as this court observed, the defendant and other members of the enterprise share a common and unambiguous purpose of carrying out a fraudulent scheme to steal from the estate, ID at 87. These cases stand in stark contrast of the instant one. Here, the evidence at the best shows that the defendant used unwitting, low-level employees to carry out anecdote tasks that facilitate his own criminality. Indeed, the government has failed to cite a single case that suggests, let alone hold, that an enterprise is established when a single bad actor uses status and authority within an organization to enable his private misdeed. The government also cite United States versus CNC and United States versus Feldman for the proposition that to establish a RICO enterprise, the government need to not show that the corporation has acted with purposeful or unlawful intent. This argument misses the mark. Defendant has never suggested that the government's enterprise evidence was insufficient because his legitimate business entities did not act with an unlawful intent. The defendant's argument is simply that the government did not prove that the charge associated in fact enterprise shared any illicit common purpose. Neither Cianci nor Feldman hold that association, in fact, enterprise can exist without its members sharing an illicit common purpose. Indeed, Cianci says the opposite. There, the court held municipal entities can be parties of a non lawful purpose, association, in fact, enterprise, as long as those who control the entity share the purposes of the enterprise. RICO does not require intention or purposeful behavior, but corporation charges as members as an association in fact. Citation omitted. A RICO enterprise imitate by an illicit common purpose can be compromised of an comprised of an associate, in fact, municipal entities and human members when the latter exposes the former to carry out the purpose. Emphasis added. ID at 83. The Cianci court expressly acknowledged that the members of the association, in fact, enterprise, must be motivated by an illicit common purpose. Even if the municipality itself need not act purposefully. As the court noted, an association, in fact, enterprise consists of people and entities can exist when the people use the organization to carry out their shared illicit common purpose. The court did not hold that the association, in fact, enterprise can consist of people whose purpose is to carry out legitimate and legal purpose. C. The government did not show common purpose of any illegal or illicit conduct as charged. The government concedes, as it must, that its indictment charges that the common purpose of the RICO enterprise was to recruit women and girls to engage in illegal sexual activity with Kelly and to produce pornography, including child pornography, government BR at 50-51. The government generally claims that it proved the illicit common purpose by almost immediately reverts back to its faulty legal argument, namely that the defendant mere use of his employees for tasks such as driving female guests from one location to another or providing a woman of unknown age defendant's phone number is sufficient to show common purpose of recruiting women for illegal sexual activity. The production of pornography. The common expressly argument that the evidence proved that Kelly used his fame and popularity in the music business, combined with a network of individuals at his disposal to target, groom, and exploit numerous victims for his own sexual gratification. After accepting this statement as true, it does not constitute sufficient evidence that the network of individuals shared a common purpose to promote defendant's illegal sexual conduct. The government relied on United States versus Menachem for the proposition that the government was only required to prove that the enterprise common purpose was to promote defendant's music and brand, not defendant illegal sexual conduct. The government grossly mischaracterized the holding of Minicone, falsely suggesting that Minicone supports its contention that an enterprise not need have an illegal common purpose if a defendant merely uses his underlining to carry out his private misdeeds. In Minicone, the defendant were charged for their alleged involvement in a wide-ranging criminal enterprise that profited from extortion, loan sharking, illegal gambling, and trafficking in stolen property. ID 1103. The defendant challenges their conviction on the grounds that the racketeering activities were not sufficient related to the racketeering enterprise, the RICO enterprise, RICO enterprise, and not the evidence of an enterprise was inefficient. ID 1106. Contrary to the government's argument, the court did not suggest an enterprise exists when the defendant is enabled to commit the predicate offense solely by virtue of his position in the enterprise. Rather, the court's statement pertained to the vertical nexus requirement between the RICO enterprise and Predicate Racketeering Act. It was not a declaration that a RICO enterprise can exist even where the members have no common purpose of carrying out an illegal course of conduct. The government spills unnecessary ink on its argument, and that the predicate offense were related to the activity of the enterprise, detailing its evidence of predicate act, government BR at 53. If the government had proved the enterprise as charged, the government's relatedness claim would be well taken. But as discussed at length, the government failed to prove an enterprise. There are no predicate offenses, just standalone charges that are time barred. The government insists that despite the fact that it charged in illicit common purpose, it was not required to prove one. Alternatively, the government claims even if it was required to prove an illicit common purpose, it satisfied its burden because defendant's employee knew he mistreated his girlfriend. The government revives its closing argument, drawing sweeping and unsupported conclusion about the evidence that borders the misrepresenting the record. Cites to the record are noticeable. Lacking, the government seemed to rely heavily on the PSR, which is pretrial services, that PSR. The pretrial services report, which is replete with hearsay evidence that were never presented to the jury. But even if the government greatly embellished version of the evidence was true, its evidence shows that a handful of employees whose employment with the defendant was short-lived turned a blind eye to defendant's occasional mistreatment of his girlfriends. All right, I'm getting tired. I'm gonna stop right at page. But let me finish this one and I'll be done because my mouth is getting tired. The government writes in its statement of fact and later incorporates into its argument that Kelly and his inner circle assisted Kelly in his professional and personal life. Also recruiting and maintaining Kelly's female victims, citing A447, whatever the numbers are. Indeed, it is never clear that the government means by recruiting and maintaining Kelly's female victim, but testimony to which the government cited back up the aggrandized narrative is devoid of facts from which the jury could have fairly concluded that the defendant's employee shared a common purpose of promoting his illegal sexual activity. For example, Navarro did not testify to a single fact from which a rational juror could conclude that he recruited or maintained defendant's victims. Indeed, the prosecutor did not even question Navarro about defendant's victim, who she never identified at any event. Isn't it supposed to be a he? She put a she there. Navarro testified to his general responsibility as a road manager that included ordering food for defendants' female guests at the studio and driving them home when asked. In a misleading fashion, prosecutor repeatedly referred the defendant's female guests when questioning his former employee, knowing that those former employees would never agree that they knowingly facilitate defendant's sexual misconduct. But the government asked the court just to assume that female guest means defendant victim. This court may not do so in some. Navarro did not utter a single word in which any rational juror could conclude that he and others shared a common purpose to ensure defendant sexual abuse women and children or produce pornography. The government also cite to Arnold's testimony as support for its common purpose evidence, claiming that Kelly's inner circle also assisted Kelly's female guests in arranging airfare, air travel, and hotel room, allowing them to visit Kelly across the United States. GovBR at page 6. A review of the citation provided by the government at A649 shows that one of Arnold's responsibility was to make sure Kelly and his team got to their destination. Arnold's testimony, as cited by the government, is devoid of a single reference of Kelly's victim or girlfriend. The government takes enormous liberty with this record that borders on misrepresentation. The government claims that the evidence of common purpose was established because Kelly Inner Circle required them to abide by several rules, including signing non-disclosure agreement and getting permission for guests to use the bathroom. The government failed to explain how rules related to non-disclosure agreement and obtaining permission to use the bathroom in a studio or house shows common purpose to promote defendants' alleged sex crime. The government cited a testimony from Diane Copeland, A1063, and Mayweather, A1282, which established nothing more than they were defendants' personal assistants who arranged travel for some of defendants' female guests, A1063, and they that they interact with defendant's girlfriend, none of whom were underage. Copeland never testified that she made arrangement for underage girl and that she was promoting defendant illegal sexual activity or production of child pornography. Mayweather noted that the defendant did not want her interacting with his girlfriend. It is unclear how this testimony shows a common purpose and to promote defendant illegal sexual conduct with women and children. Furthermore, the defendant personal assistant retrieved prescription medication for him, including Valtrex, does not mean that those assistants had any reason to know that the defendant was exposing his girlfriends to herpes without their knowledge of in states where it is illegal to do so. It certainly does not establish a common purpose to promote defendants' illegal sexual activity. The reminder of the government cited evidence merely shows that the defendant imposes rules on his employee that were sometimes harsh and that he sometimes mistreated them. Government BR at 8. For example, the government makes much of the fact that the defendant fines his employee for not abiding by his rule and allegedly required them to write letters to admit that they had done something wrong. The defendant was difficult to work with and not evidence that his employees shared the common purpose of promoting his illegal sexual conduct. In sum, the government charged the defendant with under RICO, alleging that the purpose of the enterprise was to promote defendant's illegal sexual conduct. The juror instruction set forth that theory and instructed the juror that the government was required to prove that theory. The government's evidence was sufficient. We're on page 17, top and item number D. That's where we're gonna stop, okay? Because I'm getting like tired. All right, good people. Again, I will check you guys later. Have a good one. Good night. Sleep tight. Don't let the bed bugs bite. Bye.